Welcome everyone. We're just waiting on a few more people to join the meeting. We will be with you shortly. Thank you. Welcome everyone to today's webinar. My name is Katrina Annis-Brown from the Council Engagement Team at the Office of Local Government. Today we are joined by the New South Wales Anti-Slavery Commissioner, Dr. James Cockayne, to discuss the recently published guidance of reasonable steps which are designed to assist public entities in implementing their due diligence and reporting obligations. Just a couple of housekeeping items to note before we start. For this webinar, your cameras are turned off and your microphones have been muted. These can be turned on by our conveners if needed. Closed captions functionality is available. To access this, click on the three dots at the top of your screen, select Turn on Live Captions. If the sound or video is breaking up during the webinar, please try exiting the webinar and rejoining. The chat function has been disabled for the webinar, and instead you'll see the Q&A button at the top of your screen. You can use this function to ask questions throughout the webinar. Time has been allocated to answer questions after the presentation. I'd like to begin by acknowledging the traditional owners of the land on which we are all joining this webinar today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to Aboriginal and Torres Strait Islander people joining us today. I now invite James to present today's webinar topic.
Thank you so much, and good afternoon, everyone. Great to be with you. I'm James Cockayne. I'm the New South Wales Anti-slavery Commissioner, and I'm joined today by Lucy Forbes, Acting Senior Legal Policy Officer in our team. Thanks so much for your support, Lucy. It's a real pleasure to be with you this afternoon to talk about a very important topic, the guidance that's recently been published to provide support and assistance to all of you as you meet your existing legal obligations. We'll come to the next slide, if we may, please, Lucy. I'd also like to acknowledge that I'm speaking to you today from the traditional country of the Bundjalung people up in the Northern Rivers, and I'd like to acknowledge elders past and present. We also think it's important in the Office of the Anti-Slavery Commissioner to acknowledge that many First Nations peoples have survived practices including connected to supply chains, that today would constitute modern slavery. There are more people who have experienced modern slavery around us than we might anticipate. And we'll come on and talk about numbers and how to recognize them in just a little moment. Next slide, please. Today, we're going to cover 5 topics with you. We're going to say a little bit about what modern slavery is, just to make sure we're all on the same page. We'll talk about the legal reforms in New South Wales that have brought us here to this conversation today. We'll tell you about the shared implementation framework that we've developed over the last 18 months with a range of stakeholders, including centrally the guidance. We're going to mention briefly a code of practice that we're working on around renewable energy, and we'll cover reporting and implementation towards the end. Then I'm looking forward very much to your questions. So thank you. We'll come on directly to the next slide, please. We think it's important to be clear what modern slavery is. Centrally, we're talking about a range of offences that involve one person or organisation treating another as if they owned them. It's obviously not legal to own anybody anymore, but unfortunately, we still have people behaving as if they own other people. So that might involve, for example, restricting their ability to move from their workplace or their household. It might involve abuse in that place, debt bondage. It might involve such a restriction of their engagement with society that it rises to the level of servitude. And commonly, it involves forced labour. We'll come on and say a bit more about these things shortly. Sadly, there are thought to be about 50 million people around the world living in these conditions today. About 22 million of those are in forced marriage, and the remainder are in various forms of forced labour of different kinds. The best available survey-based estimate says that 41,000 people of those people are here in Australia. And if we use historical reporting patterns, that probably means about 16,400 people in modern slavery in New South Wales. Of course, we can also be connected to modern slavery, particularly forced labour that occurs in supply chains overseas, but that can also occur in a commercial context here in New South Wales, for example, in agriculture, in cleaning services, in some security services, perhaps selling services that you procure yourselves. Occasionally, we do see modern slavery risks in entities' own operations in the way that they manage their workforce. It's a rarer instance, particularly for public sector actors, but it does happen and it can arise. So something to be mindful of in your own directly provided services. We think that the caseload of modern slavery cases here in New South Wales over their lifetime will cost the public purse around $9.6 billion. So it's a big impost on ratepayers and taxpayers. And it's a good reason for thinking that a little bit of prevention might go a long way in addressing the impacts that we're seeing. Next slide, please. As I mentioned, there are a number of different modern slavery offences that are covered under, if we could just go back, thanks so much, Lucy. A number of different modern slavery offences covered under the Schedule 2 of the Modern Slavery Act. You can look them up there if you're interested. There are a number of things under both state criminal law and indeed Commonwealth criminal law. The conduct in question doesn't have to occur in New South Wales for it to constitute modern slavery, and therefore for it to be relevant to your modern slavery risk identification and risk management activities. And the recurring theme, as I said, is across those offences is one person being treated as if they are owned by another person. Come on, a couple of slides now. Thanks, Lucy. So what are the legal reforms that got us to this position today? Well, there are a number of reforms that emerged out of acts adopted in 2018 and 2021, which in particular introduced changes to the language in the Local Government Act to take reasonable steps to ensure that goods and services procured by and for the council are not the product of modern slavery within the meaning of the Modern Slavery Act. Those are also accompanied by certain reporting obligations, which boil down to the annual report needing to address reasonable steps and any significant operational issues that I have formally identified to a local council. There's also the potential for the New South Wales Auditor General to carry out a modern slavery audit. These legal reforms gave the Auditor General a specific modern slavery audit power, which hasn't yet been exercised, but does cover any entity that the Auditor General is already able to, or already has jurisdiction over. Next slide, please. So there are, of course, both state and federal Modern Slavery Acts with exactly the same name, unhelpfully, Modern Slavery Act of 2018. They operate side by side. So the Commonwealth Modern Slavery Act, which you might have learned about perhaps in dealing with some of your larger suppliers, it focuses on private sector corporate due diligence, and in particular at the moment for entities with an annual turnover of more than $100 million. There's a possibility that that might be dropped to $50 million. You see the bullet point on the right-hand side that there was a review of that act not so long ago. The federal government is considering that and is considering enlarging the obligations under that federal act. None of your organisations, if you're working with local councils, are likely to be caught by that act, but they are caught by the New South Wales Act, which essentially doesn't duplicate the Commonwealth scheme. It sets up a parallel reporting arrangement for public entities in New South Wales. Over 400 public entities in New South Wales have these obligations. So not only local councils, but also all New South Wales government entities, local Aboriginal land councils, 10 universities established in New South Wales, and a range of other entities as well. So you're not on your own in this context. This is an effort undertaken by Parliament to strengthen modern slavery risk management across all public buying in New South Wales. And that actually offers important opportunities for thinking about how we will be able to wrap our arms around some of these challenges in the future and encourage collaboration across different public entities to develop perhaps even collective solutions to some of the risks they're seeking to manage. Next slide, please. So since there are more than 400 entities that have these obligations, over the last 20 months or so, I've been working with a range of organisations to develop what we call a shared implementation, in the sense that it's shared by actors operating in different procurement regimes, those that operate under the New South Wales Government regime, the Public Works and Procurement Act, those operating under the Local Government Act, and a range of others that actually aren't falling within either of those particular regimes. It has 5 elements: the guidance, which we're going to come on and talk about, model contract clauses, model tender clauses, both of which you can use as resources as you seek to implement the guidance, an inherent risk identification tool, which we'll come on and talk about, and yet to be published, the public register, which we'll also explain. We are producing, and we'll be producing even more resources that break all of this down into bite-sized chunks, so that you don't have to wade through the 200-page guidance document, which we know is large, but you will have access to bite-sized, more digestible information outputs that you can incorporate into your practice. So keep an eye on our website. More details available later in the presentation. We will also be increasingly providing templates for you to use, and there will be crosswalks from the guidance to codes of practice that look at modern slavery risk management in very specific supply chains. And we'll come on and talk about one of those a little later. Next slide, please. So I'm going to walk you now through the different aspects of this shared implementation framework. We'll begin in a moment with the guidance on reasonable steps. You might like to get out your phone and point it at the QR code on site. That will take you directly to the guidance on reasonable steps, so you can follow along and have a bit more of an investigation if you'd like to. Next slide, please. So the guidance contains 7 reasonable steps. They're pretty straightforward at one level. First of all, committing is then incorporating modern slavery risk management into your planning, your sourcing, and your contract management activities. Undertaking steps to ensure effective remedy where there are modern slavery harms occurring in the supply chains of products that you're purchasing or services that you're procuring. A reporting step and a continuous improvement commitment. Next slide, please. Now, for each of these reasonable steps, the guidance contains a chapter that contains similar information. So a discussion of the overview of what's required by that particular reasonable step. And for each of them, we break them down into between 2 and 4 substeps. The chapter also goes on to specify the data that you should be collecting to demonstrate the work that you've done to achieve that reasonable step, and that will then go into your reporting. And I'll talk a bit more about reporting in a moment. There's a discussion of how this all works and some of the challenges you're likely to encounter as you seek to do this work, considerations you need to take into account. We give numerous good practice examples, so real life examples of how organisations, and usually in the public sector, but sometimes in the private sector, are doing this work themselves. Hallmarks of best practice, so stretch goals, you might call them, and then a list of further resources that you can dig into if you need additional ideas and guidance. Next slide, please. This is a list of all of the appendices. So you see there's 80 pages just of appendices to the guidance. And the reason we list that out here is to show you that there's a lot of granular information available to help you understand what's going on in the guidance and how to incorporate all of this into your own practice over time. And I want to stress that over time. I'll say a little bit more about the implementation timelines, but we absolutely recognize that there is a lot to digest here into your practice, and that local councils have procurement capabilities of very varied magnitude and resourcing. That is certainly a relevant factor when considering what is reasonable, and we'll come on and say a little bit more about that in a moment. But this is information that sets out a pathway for local councils to move along in the years ahead. And we very much consider a part of our role to be to support all of you in that process of capability development that you'll all be undergoing, will all be undergoing in the years ahead. This information is included to help you figure out what that pathway is going to look like and get organised to move along that pathway. Next slide, please. Now, I mentioned that your capability level is really important for understanding what a reasonable step is. So part of what the guidance does is it provides this matrix to help you understand for any given procurement transaction what level of diligence is due. And it's based on 2 factors. The first is how inherently modern slavery risky is procuring that particular type of good or service. And we'll come on and show you in a moment how we help you figure that out. The second is, what is the capability level of your organisation? So the lower the capability level, the less is expected of an organisation, both under our guidance, and I should clarify that our guidance draws on international commitments Australia has made to the UN Guiding Principles on Business and Human Rights and the relevant OECD due diligence. So both of those frameworks make clear that what's expected by way of due diligence from a very small organisation can't be the same as what's expected of a very large organisation with much more resources to expend on this kind of procurement activity and risk management activity. So this matrix helps you figure out where you're landing in any given procurement level. Now, obviously, to do that, you need to know what is your capability level. And there is a tool within the guidance. There is information about how to figure out what capability level your particular local government organisation is based on the existing taxonomies that are available and will be familiar to you. So that's in a sense predetermined for you. And then you only need to figure out what is the inherent modern slavery risk level of the particular procurement you're undertaking. Next slide, please. This is an example of a real-life example included in the guidance. This is how one Australian government agency incorporated modern slavery risk information into its tender process. I'm not going to spend any particular time on this, but this is just to show you that there are such examples in the guidance that will allow you to figure out what the pathway for your work actually looks like in practice. Next slide, please. Another example is What do you do when you actually identify victims? Are you expected to report those modern slavery cases to local authorities? What if the local authorities are in some way implicated in the activity, which is not unheard of in the modern slavery context? Should you be reporting that to an organisation that has a cloud over it? This workflow helps you work through understanding what the reporting pathway might look like. Again, really just an example, but there's practical information in the guidance to help you through these different scenarios. Next slide, please. We also mentioned some other tools that we're providing alongside the guidance. One is the shared responsibility-based model contract clause. So this is a clause that really moves away from a representation and warranty-based approach to contracting, and instead provides you a framework for understanding where modern slavery incidents do arise in the supply chain, as they will from time to time. What are the responsibilities of the buyer and the supplier for managing that situation? Traditionally, the answer has often been to head for the exit and to abandon that supplier. But in some contexts, that may actually increase the risks of modern slavery for the workers. And since the whole instinct here of the legislation is to reduce modern slavery risk, in this particular model contract clause, or there's two of them for two different levels of due diligence, the approach that's taken is again reflective of the international practice that's emerged, which involves staying and engaging with the supplier to help them develop and remediate their business practices so that they can continue to provide you the goods and services that you need at value for money, while ensuring that modern slavery is not occurring in the production and distribution of those goods and services. So as I said, two different model contract clauses for different levels of diligence that are due. We often get asked, what's the deal if suppliers won't use the terms and conditions set out in these contract clauses and insist on using their own? What the reasonable steps and the international standards require then is development and use of leverage. So thinking about what you can do to incentivize them to participate in this kind of approach, either in an individual negotiation or through the way that you establish the procurement process, the tender specifications, for example, or through your ongoing engagement with that organisation. And of course, through collective leverage. Local councils as a group have quite considerable buying power potentially. How should councils collaborate with their suppliers during the term of the contract? That is a topic that is addressed at some length in the guidance, and it essentially involves, as I said, collaborating with your suppliers to help them develop the capabilities to give you the goods and services you need without relying on modern slavery. That can be a long-term proposition, and we recognise that may require contract management and supplier engagement capabilities that some councils won't yet have. So again, there's a process here that the sector will need to undergo in the years ahead to think about how it can develop those capabilities in both an effective and a cost-efficient manner, which might mean collaboratively, and it might mean not only local council collaboration, but again, collaboration with New South Wales government and other public sector entities who are facing exactly the same questions. Next slide, please. In addition to the model contract clauses, we also provide model tender clauses based on overseas best practice, notably from the UK Crown procurement, and those are designed to help you at different levels of due diligence incorporate these kinds of factors into your supplier selection process. Next slide, please. Now, I mentioned earlier that we provide a tool that allows you to identify what level of inherent risk is associated with buying a particular product or service. This is available for everybody, freely available on our website. We call it the Inherent Risk Identification Tool. I know it's incredibly sexy and original name, but hey, at least you get what's advertised on the cover. It's a lookup tool that allows you to look up a particular product category and get an answer from us as to how inherently risky we think that purchasing that particular product is. Now, we do it at the category level. So it may be that within that category, there's significant variation by product or indeed by supplier. So this is just a first step that puts you all on a level playing field for understanding how inherently risky a particular product category is. It's still incumbent on buyers to go through their own due diligence when looking at the specific product they're procuring and indeed the specific supplier that they're seeking to engage. Next slide, please. The tool includes quite a lot of information. It's based on the New South Wales Government Whole of Government Procurement Taxonomy. And next slide, please. It includes quite a bit of information about how we identify, thanks Lucy, how we identify the risk score so that you can look at yourselves at the underlying sources and make your own assessment about whether the thing that you're buying may not be as risky as the general description we give for a particular reason. Next slide, please. The last element of the shared implementation framework is this public register. So this is required under Section 26 of the Modern Slavery Act. It will identify non-conforming entities. So that's entities that aren't meeting their due diligence and reporting obligations. It's empty. There are no such entities right now. We will be publishing it soon, but probably as an empty set, because our view is that this is a lot of work to digest, and there's going to need to be quite a process of implementation over the coming years to support that implementation. So where there are questions about conformance with the guidance, our first instinct won't be to simply put entities on the register. There'll be a lot of engagement from our side to help entities develop the capabilities that they need to meet these expectations. Next slide, please. I wanted to say a quick word about the code of practice we're developing. Again, another QR code you can follow to the discussion paper that we published last year about this. We're partnering with the Clean Energy Council to develop a code of practice specifically for renewable energy value chains. So this is about how do you identify modern slavery risk and how do you manage that risk in purchasing renewable energy related goods and services. So this is in a sense supplementary guidance for one particular supply chain or set of supply chains that sits on top of the code of practice, the guidance on reasonable steps. The guidance on reasonable steps says where there's a code of practice, look also to that for more detailed guidance. We'll be publishing a draft code, we believe, in a couple of months for public feedback through a transparent consultation process, and we hope to have the code of practice fully settled and published later this year. Next slide, please. Let me say a quick word about reporting and implementation. I know this is on a lot of, probably a lot of minds of people in the audience. So the guidance sets out in quite a lot of detail what data should be collected and reported on for each reasonable step. In a sense, we're asking you to show the efforts you've been undertaking to achieve the outcomes identified in the reasonable steps document. That is to be shared in your annual reporting as is required under the Local Government Act. We request that in addition you provide that information directly to us through a form that we make available. The form reflects the proposed reporting arrangements set out in, I believe it's Appendix K of the guidance document. Which collects all of that information about what data you should be reporting that we've set out for each reasonable step along the way. What this will allow us to do is to develop our own analytic and feedback capability to feed back to reporting entities areas where we think there's opportunities for improvement and capabilities that they might want to develop. It also, though, allows us to work at the system level to see where there are a number of organizations that might be struggling with a particular issue or that are active in a risky supply chain. We can then allocate our resources, just as we expect you to the areas that have the greatest risk to people and help develop capabilities in those areas. Next slide, please. This is the annual reporting that I've just been talking about on the left. We're also aiming later this year to introduce transaction level reporting, but only for heightened modern slavery due diligence. So that's where there is a procurement activity or operational activity that involves a good or service that we've identified in the inherent risk identification tool as high risk. There's only 27 of those categories out of about 300 and I think it's 375 or something like that overall in the full taxonomy. So what we're looking to do is to have a reporting system that is fairly automated that allows us to collect information about those higher level transactions in order, again, to understand where risk is pooling and how we can support entities to manage that risk effectively. We'll have a little bit more to say about that in the months ahead. Next slide, please. This is just a little excerpt from the reporting form to show the kind of information that we're looking to gather. Next slide, please. As you'll see in this next slide, this is just the beginning of this. Thanks, Lucy. As you'll see, this is just the beginning of the form where we set out the different information that we are looking for. In this case, it's right at the beginning around the commit reasonable step. So it's looking at stakeholder engagement. What steps did your entity take to engage with the stakeholders during the reporting period in relation to modern slavery? And did you engage with external stakeholders on modern slavery risks in this reporting period? There's a lot of description of what those concepts mean in the guidance itself. So it should be fairly easy to follow along. Next slide, please. Now, a quick word on implementation. So the guidance has been in effect since the 1st of January 2024. Of course, the reasonable steps obligations themselves have been in effect for 18 months prior to that. It's just taken a while to get this guidance to you, not least because I wasn't appointed to my role. The first person in the role, I wasn't appointed to the role until August of 2022. The expectation is that the guidance doesn't apply to activities prior to the 1st of January. But you're welcome to use it as inspiration for reporting about the things you might have already been doing to identify and manage modern slavery risk prior to the 1st of January 2024. As I stressed earlier, there's no expectation of immediate and complete implementation of 200 pages of guidance. We do anticipate a process of improvement, and in improving your capabilities, you should focus on areas that are the riskiest to people. So focus on those high risk transactions and procurement areas. Of course, you need to look at your own procurement portfolio to understand where those might be. And there's going to also be a process we expect of innovation and collaboration as organizations think about how to pool resources, work together, share information to best manage this risk going forward. We anticipate ourselves having a role to play there in providing education and training for reporting entities for the years ahead. And one way we'll do that is through convening collaborative learning opportunities, such as the inaugural New South Wales Anti-Slavery Forum, which will be held on the 21st and 22nd of May in Sydney. Day 2 will focus entirely on these responsible commercial conduct questions. So a lot on procurement, a lot on how to actually implement the guidance. For example, how to engage effectively with stakeholders. We'll look at specific supply chains like the ICT supply chain, the cleaning supply chain, what's going on in those spaces, how can you find the capabilities to understand and manage risk in those particular supply chains. And we'll look at some other things too, like solar power. Next slide, please. 3 particular things I'd encourage you to think about at the moment. The first is follow the risk. So focus your limited time and resources, and I know for some of you that's extremely limited. Focus that on where you think heightened modern slavery due diligence is due. So that's higher risk product categories. Again, we make that very easy for you to figure out. You just need to use the inherent risk identification tool and essentially overlay it over your own procurement spend. The spend itself is not a determinative factor. What matters is not the size, the amount of money you're using in an area. It's what matters more is how risky it is to people to purchase that product. Secondly, if you're in doubt about where to start with the first reasonable step. Stands to reason, I know, but you know, there's no reason not to be obvious about this. That is commit. So that involves developing an internal modern slavery policy, a modern slavery risk management plan, mapping your risks, and beginning to develop those relationships with at-risk stakeholders, which may need to be through intermediaries in order to understand how you're going to effectively manage that risk. We also, third, provide some clear signals in the guidance about areas that we are going to focus our monitoring on in the next few years. So for reporting occurring this year, we're going to focus in particular on activities around ICT, cleaning services, and renewables. For reporting that occurs next year, we will then add a focus on domestic agriculture. And for reporting that occurs the following year, we will focus more on construction. Next slide, please. So that's it for the presentation. Thank you so much for your time and attention. You can contact us through any of the items you see here on the page. The last QR code is for you to sign up to our newsletter if you'd like to keep informed. We have a new newsletter specifically focused on due diligence, news and resources. You're very welcome to sign up to that. That's where we'll be announcing our new materials, training opportunities, new developments. There might be new versions of the IRIT or of the guidance itself in time. Please do sign up there, and we'd love to hear from you at any point. Beginning now, I think we might have a Q&A session.
Yes, thank you, James. So the first participant has made more of a comment than a question. So just referring to Council's annual report. So this participant is saying the modern slavery report was included in our most recent annual report. And as I worked through what was required, I became overwhelmed in that there were so many line items to be complied with that I honestly do not think that a small rural council can meet all of the requirements. And just a query as to what do other smaller rural councils think?
Is that something you'd like me to respond to, not being a local council myself? Or
I'm not sure. Perhaps you could respond to the first part of that, I suppose,
Sure.
Statement about it being difficult to implement and the fact that there were so many line items to be complied with.
Yeah, sure. Look, we do recognise there's a lot of work laid out here, and in developing this guidance, because we had to deal with organisations of hugely varying capabilities and resourcing footprints, we had a bit of a dilemma. Do we go for something comprehensive that really sets out for all organisations, including the largest, what good looks like, or do we need to come up with different packages for everybody? Or at least for different scales. And there was a lot of urgency from organisations to get something fairly comprehensive out because they had these legal obligations in place since the 1st of July 2022 and felt that they were operating without the level of granularity in the guidance that they were looking for. So we recognise that in providing comprehensive information that it does look overwhelming. I think what we want to stress is two things. First of all, that what's required under the legislation is reasonable steps. That's the bottom line, reasonable steps. So obviously reasonable must be linked in part to your capability, your resourcing level, and the speed at which you can move in taking the steps needed to identify modern slavery risk and manage that risk is going to be reflective of your capabilities. We recognise that. That's reflected in the matrix that I showed you with the risk and the capability level, but it will also be reflected in the way that we monitor and evaluate and then consult around effectiveness as the law requires me to on the reporting that we're seeing. It's a journey that we're all going to be going on together here, and different organisations will be able to move at different speeds. So we will be providing support and assistance along that journey with training and capability development. I think the other thing I would say is we do recognise absolutely that in the first encounter, this can look like a massive cost centre for organisations. What we would say to you is, yes, there is an investment that needs to be made here, and we're very clear on that too when we speak to state government as well, that this is not a cost neutral exercise. But there are considerable payoffs at both the organisational and the societal level. So the societal level are probably a bit more obvious: reduction of modern slavery, bring that cost to the ratepayer and the taxpayer down. But at the organizational level, the development of the capabilities to understand what's going on in your supply chain is going to equip you not only to be able to address modern slavery risks, but to address a number of other risks that arise in supply chain. So risks of supply disruption, something that was pretty massive for all organizations, including local councils during COVID, better ability to negotiate with suppliers, stronger ability to manage other sources of risk, such as environmental risk. So that development of improved transparency and relationships, I would say, along your supply chain will stand you in good stead in a number of other ways.
Thanks, James. So the next question we have is, are there any examples of how councils may collect, store and present the data required for the mandatory reporting for each reasonable step?
I'm sorry, could you just repeat that? I didn't quite get that.
No, sure. Are there any examples of how councils may collect, store and present the data required for the mandatory reporting for each reasonable step?
The examples. I mean, this is at council's discretion. So certainly we know that there are external providers such as LGP that are taking a very active interest in this work and developing appropriate capabilities, but it's really up to each council to develop that capability for how to collect and store that information required. It will be quite bespoke to each organisation to reflect on what it's doing in year on year to meet the requirements. If I've understood the question correctly, I may not have. Apologies if you asked and I haven't understood that correctly.
Okay, thanks, James. So the next one is, local councils have obligations under the Local Government General Regulation not to negotiate with suppliers outside the tender period. This seems to conflict with the collaborative discussions encouraged with suppliers regarding inclusion of modern slavery clauses in one form or another. Can the Commissioner or OLG please advise whether there are any plans for changes to the local government legislation to allow negotiation of contract terms after tender close?
Yeah, so we would not necessarily expect negotiation of contract terms after the tender close. So we would encourage you to think about reflecting the necessary arrangements in tendering. Now, we recognise that, of course, tenders that are completed or underway or initiated now, that's out of the question. So no question there. But we provide the tender clause and the model tender clause and the model contract clause so that those can be incorporated from the outset. What the model contract clause does envisage is that where it creates a little mini framework for where a modern slavery incident arises, for how the supplier and buyer will collaborate in that situation to remedy and address the modern slavery. I wouldn't think that that's what's meant by the question here around negotiation, because there's certainly information exchange and cooperation in that context, but it's not a negotiation of the contractual terms and provisions. So I think that the short answer to the question is we don't understand that there is any inconsistency here with the local government general regulation. So we don't have any plans for changes to the legislation at this point. I see the question is from Ms. Reid, if you think I've misunderstood or in any way not fully appreciating the context of what you're saying, I'm very happy to hear from you directly.
Thank you.
Now or by email, if easier.
Sorry to jump in there, James. The next one is the GRS, page 14, states renewable energy is a focus for the 2025 calendar year. Could slides be updated to reflect this?
Sure. Apologies if there's an inconsistency. Different organisations have different reporting cycles. So I guess it depends whether I think what I said just now was that we will focus on that for entities that report in 2024. So there I was referring to when entities are reporting. The monitoring activity itself for us would then occur in the 25, should be financial year, not calendar year. So we'll certainly check that. Again, apologies if there's an inconsistency there.
So we have a question here, but it's more for OLG, and I believe I may need to take this one on notice. I understand that the guidelines are expected to be integrated through incorporation by reference into the OLG tendering guidelines. When is this expected to occur? Unless you have anything to provide, James, I'm happy to take that one on notice.
I can't speak to the timeline. That's certainly also my understanding, but I can't speak to the timeline for the development of the tendering guidelines.
All right, thank you. Next one is, do you have a model policy template?
Not yet, but it is a work in progress and coming fairly soon. Lucy, I don't know if there's anything more you want to say on that front. Lucy and our colleague Emma are beavering away on that and many other things.
We are, as James said, we're working on, providing information in, I guess, a more digestible form, particularly as a priority on the modern slavery policy. There is guidance in the guidance material on how to develop a policy. I suppose what we want to ensure with modern slavery policies is that there's something that's really, it's not a document that's sort of set and forget within your system, and it's certainly not a one-size-fits-all policy. So obviously what's going to be appropriate for Griffith City Council may not be appropriate for Sydney City Council, and certainly won't be appropriate for Transport for New South Wales. Another point to make is also that there's not an expectation that you'll, develop a entirely new, fresh policy that, is not in any way integrated into the existing systems you have going on. We really want to make sure that the sort of any modern slavery policy is integrated within your existing policy infrastructure and sort of, ties into risk management frameworks and so on and so forth that you already have in place. Because that's obviously going to make it much easier for everyone to follow it and everyone to implement it. So we will, as a priority, be providing additional guidance on how to develop modern slavery policies. I think a template will have to take into account the range of entities that such a policy would have to be applicable for.
What is the due date for the uploading of annual reporting to the portal?
So that depends on your statutory annual reporting obligation. Well, yes, that's the short answer. And then there might be, I'm sorry, I can't remember off the top of my head, maybe Lucy can, whether the guidance specifies an additional number of days after that for the sharing of the information via our online form. I'm not sure we do actually for that particular one.
No, I don't think there's a specific provision for when we expect it to be provided in the online form. The idea is that the information, where possible, should be replicated in the annual report in the same format that it goes into the online form, which makes it a pretty easy Control-C, Control-V job for you when you are uploading it.
Thanks, Lucy.
Yes, thanks, Lucy. Just to go back to the question regarding the tendering guidelines, I have some information here. OLG is currently working on the tendering guidelines and hopes to issue a consultation draft later this year. This work needs to be accommodated within other priorities, including support for the 2024 local government elections. All right. So the next question we have is there a plan for OLG or OASC to provide a modern slavery policy? I think that's yes.
Sorry, a model modern slavery policy?
A model, yes, a model modern slavery policy.
Yeah, I mean, I think that's probably pretty similar to the model policy template question we just took, which I think Lucy answered very capably. it's difficult given we have 420 entities covering everything from Transport for New South Wales to very, very small agencies with fewer than 10 employees as a whole, to have one policy template for everybody. But as Lucy said, please do look at the relevant section of the guidance. It sets out what the functional requirements of the policy are. So I would stress, for example, that it needs to be approved by the senior governing body. As Lucy said, it doesn't have to be standalone. If you decide this fits better in our existing risk and audit policy or something like that, we just add a few extra provisions, something like that, then go for your lives. It needs to work in your context. But the guidance sets out functionally what it should do, kinds of issues it should address. And as Lucy said, she'll be developing, well, we're developing at the moment, some additional bite-sized guidance to make it really easy to find on our website, just so you immediately see how to develop a modern slavery policy, and don't have to go searching yourselves in the guidance. For now, though, unfortunately, you do have to go searching in the guidance. It's not too tricky. It's under the first, it's in the chapter discussing the first reasonable step, commit.
Thanks, James. The next question is, has any work been completed to incorporate modern slavery contract terms within Australian standard contracts?
Not Australian standard contracts yet, but we've certainly had a lot of interest in this work from outside New South Wales, if I can put it that way. Certain federal government agencies observed the extensive consultations that went into developing this guidance. We're in pretty close contact also with the Australasian Procurement and Construction Council. And we know that a number of private sector entities are already beginning to incorporate the guidance and the clauses and so on into their own practices. So, I mean, it's only published on the 23rd of December. We're only a few months into this being visible. I think there's a lot of work ahead, and we'd be, very, very happy if there's greater uptake of this approach. I think the model clauses are just that. They're model clauses. They're going to probably be adapted a little bit when they are incorporated into specific contracting arrangements. I'm sure we'll all learn quite a bit from that process. So it may be that we find in time there's a need to develop them in further ways. But as I said, if they can find their way into to other standards, I think that would be potentially very impactful.
Thank you, James. Can you please clarify whether we are expected to renegotiate contracts prior to the 1st of January 2024? The guidance on page 13 states exceptionally where modern slavery risks in an ongoing operational activity or procurement are heightened, covered entities must not only use leverage but also develop it where they lack it. This is consistent with Australia's commitment to the UN guiding principles on business and human rights and recent adherence to the OECD Council recommendation on the role of government in promoting responsible business conduct. In some cases, especially where there is a salient risk of ongoing modern slavery in the performance of the contract, this could mean that entities do need to consider exploring contractual adjustments in order to develop this leverage.
Yeah, so the bottom line is that you're not necessarily expected to renegotiate contracts prior to the 1st of January 2024, but there are expectations that you will manage risk going forward. So if you have a long-term contract and you see that as a significant source of modern slavery risk, you have that option open if you've decided that that's necessary to give you the ability to manage risk safely. Of course, you have another option open potentially, depending on the terms of the existing contract, which might be to terminate the contract. But again, what I would come back to is that what's required under the legislation is reasonable steps. So there's a certain judgment and discretion that's going to have to be exercised on your part as to whether that's something you would countenance in any given case. I would say, and we use the word here exceptionally, I think it's going to be exceptional to open up the terms of contracts. We're really talking about situations where you appear to be locked into a contract that you really don't want to be locked into because you've decided the modern slavery risk is actually so significant that it's worth opening up the contract to address that. That's going to be a pretty exceptional case. The general rule is we're not expecting to see renegotiation in any form of contracts concluded before the 1st of January.
And I suppose another. Oh, sorry.
No, sorry.
I suppose another option where, perhaps the risk doesn't rise to the level where you'd be really looking at contractual adjustment or potentially even termination, might be looking at the contract you have and saying, well, are there obligations in this contract for the supplier to comply with workplace laws or, general human rights clauses or something that perhaps you can leverage in that way?
Yep, well said.
That appears to be the end of the questions. James, would you like to make any final comments before we wrap up?
No, just to emphasise that this is a process that we're all going to go through over the coming years. So there really isn't an expectation that, particularly in this first reporting cycle, that every I will be dotted, every T will be crossed. It's a question of undertaking reasonable efforts and reasonable steps. And we'll be approaching it very much in that regard. Even the process of understanding these obligations, reflecting them in the reporting, development of the reporting, how to actually lodge the forms, all that is brand new. We do appreciate that. So I think the expectation is under the legislation that councils give it their best shot, if I can put it that colloquial way, at least in this first cycle, and then we will work with you in the years ahead to help you develop those capabilities. We are very mindful of the huge variability in resourcing available to all of you. I do want to emphasise that, and therefore, and equally, actually, I would say we're mindful that you're going to be dealing with suppliers that themselves have huge variability in their capabilities. So there's another part of this conversation that's coming down the pipe eventually, which is about supplier engagement and how we do that effectively. Again, I think there's a real need to think about collective and collaborative approaches to make sure we aren't asking suppliers for the same information 15 different times, 15 different ways, from 15 different buyers. There will be more happening in this space across New South Wales government and beyond to develop the frameworks and capabilities for addressing that challenge as well. So I would really encourage you, please, to stay in touch with me and my team to sign up for that newsletter, because this will be an evolving space over the next couple of years. And I think you will find that there are resources, training opportunities, engagement opportunities that will help you develop your thinking and your own muscles in this regard in the years ahead. Thank you so much for the time today and the opportunity to meet and speak with you all, and happy reading.
Thank you to James for presenting on this important topic. I would like to thank everyone for taking the time out of their very busy schedules to join us today. This concludes the webinar, and enjoy the rest of your day.
Thanks so much.